With the Southport attacker about to be sentenced, a number of people have asked about plea bargains, because some people have suggested, oh, is there some sort of plea bargain going on? Well, the answer to that is no, because we don't officially have plea bargaining in England and Wales. But this gives me an opportunity to explain exactly how sentencing does work and some of the factors, especially when people plead guilty. But I need to explain the sort of evolution of the history and how we got to where we are today. So I'd like to take you back to before 2005. And I'll give you an anecdote from my own experience. Like I said, officially there was just no plea bargaining or sentence indications whatsoever. But I once had to pop back up to Bradford, my hometown, because I had a thing where I wanted to do a case in every Crown Court in the country. And the clerks liked that. They said, oh, he's a good traveller. So I got sent off to Bradford. I duly arrived in the morning. I went through security. And there was a note waiting for me. And they said, oh, you Mr. Robertshaw? Yeah. Judge wants a word. Oh, I'm in trouble already. What's going on? So I went up, found the judge, went into the judge's room. And the judge was lovely. Would like a cup of tea. Oh, nice journey. Welcome back. Prodigal son and all that sort of thing. And he just sort of sat there and just chatting. He goes, now, because this was listed for sort of a 3-day trial. I can't remember what the offence was. Some typical Bradford type thing. But he says, I was out last night with your prosecutor, because we used to be in the same chambers, and we're having a little chat about this case. And it occurred to me that, notwithstanding the nature of the offence and the seriousness and all that, and, the late stage of the proceedings, it seemed to both of us that with the right amount of remorse, even at this late stage, this could be a case where if somebody owns it, then maybe nobody has to go to prison. Like, oh, okay. He said, anyway, I'm keeping it. Would you like to have a word with your client? So I duly popped down to the cells to my very not guilty client, a very insistent not guilty. I had been up to then. And I said, look, I've got to tell you this, but just to let you know, I'm all ready to fight the trial. I know what you say. But the judge has just indicated that if you cough to it even now, you're not going inside. Yeah, great. What? Yeah, I'll take it. No, I'll do it. Okay, well, you've got to be good. Yeah, whatever. Now, in those days, we used to do what we called endorsing the brief, because it was all like the old paper briefs with your pink string tied round them, or white if you're the prosecution. Although that's not the same in every area. There's a Rumpole story about that, where they get mixed up with colour tape to, with unfortunate results. But what we would do is, if it was somebody going to plead guilty, we would get them to write on the brief, I understand that I am pleading guilty, and this means that I accept that I did it, etc., all signed, so that down the line, nobody's saying, well, I was pressurised into doing it. So you would actually get them to endorse the brief. So, he says, yep, I'll do that. So I go, have a quick word with the usher, just to let you know, my client now, you can put the indictment again, he's going to cough to it. And interestingly, we were listed not before 12. They'd put a load of other mentions and sentences and bail applications before us. So the usher goes in, and this is before anything had started, and said, oh, judge will get you on now if you want. So we were first on the list. So it's please put the indictment again. How do you plead? Guilty or not guilty? Guilty. And then just said, okay, blah, 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 blah. Terrible, terrible thing. However, you've been man enough to own up to this, and you've taken responsibility. So although this is clearly suitable for a custodial sentence, I think in these extraordinary circumstances, I can suspend it. I was about 11 o'clock. I was back on the doorstep, just getting ready to get the train back down to London, and I had actually arranged to see all my friends and things, and catch up with people. But that's how it used to be done. Now, officially, that never happened. But you speak to any barrister of that era, and that was a very common practice, the quiet word with the judge. However, in 2005, in a case called Goodyear, they formalised the procedure, and now we have what are called Goodyear indications. And what happens there is you approach the judge, and you say, usually as defence counsel, obviously, and you say, if my guy was to plead, not saying he would, but what would he be looking at? And the judge can give a sentence, say, well, it would be no more than this. I mean, it could give a range and say, well, obviously there might be some mitigation, but even on the worst case scenario, this is the maximum I would give. Now, in the same way that in America, in a lot of jurisdictions, judges aren't bound by plea bargains. In this case, even if the judge gives the indication, the Attorney General is not bound by it. So if the Attorney General thinks that the sentence is unduly lenient, they can appeal it. And the rules are that, as a matter of our own code of conduct, defence counsel, it's an obligation. We have to explain that to our client. That, look, whatever happens today, there is always a chance that the Attorney General could intervene and it could go up. And again, you make a note of that, endorse the brief. Also, in open court, because if you are going to plead to this and you've sort of semi-agreed it, what the prosecution will do is they will highlight the sentencing guidelines, but because it's all sort of semi-done and dusted, they'll just say, well, this is the normal range for this sort of thing. But they will also themselves say in open court, of course, we must remind Your Honour that this, even if you sentence today, this does not negate the the possibility of the Attorney General appealing this. It was a very interesting case, actually. There were a couple of cases where that wasn't done. And then the Court of Appeal, when the Attorney General has done an Attorney General's reference, they said, because the defendant wasn't put on notice that was a possibility, we're going to dismiss the appeal. Which I thought was an interesting one, because like I say, there is the duty on defence counsel to tell them anyway. So arguably the Court of Appeal could have said, well, we can just presume defence counsel did their job and they were warned of this. But that's what we call a Goodyear indication. Like I say, the judge just says, if it was a guilty plea, and assuming I've got all the facts, and what you will then do is you will try and do an agreed basis of plea with the prosecution. This is exactly what we are pleading guilty to, not just the offence itself, but this factual basis. And you get all the information out there in advance, so that the judge isn't surprised and says, oh, well, hang on, had you have told me that beforehand, my view might have been different. But that moves us on to, how do you agree exactly what somebody has pleaded to? And this, we'll talk about something called Newton hearings. Like I say, if somebody pleads guilty to the offence, when you're charged with an offence, you have the statement of the offence and the particulars of the offence. So it could be count 1, theft, contrary to the Theft Act, Section 1, 1968, Section 1. Particulars of offence in that went into a premises and stole X thousand pounds. But what if they say, well, I admit the theft, but I didn't take that much. Oh. Oops, excuse me 1 second. Sorry to be rude. Sorry about that. Where were we? Oh, it's so rude when people ring. So you're saying, I plead guilty to this, but not on those facts. The actual factual basis of the plea is different. Well, it depends. Would it make a difference to sentence? If you're accused of stealing £500 and you actually only stole £400, the judge might say, well, it doesn't really matter, does it? But what if the factual basis is very distinct, such that it would affect sentence? And this all comes back to what we call a Newton hearing, possibly. And this is a case called Crown and Newton. Now, I'll try and give you the facts of this, but you might want to go and Google it. Just Google Crown, as in R, and V, Newton. That's how we pronounce RV. Over here, we call it Crown and. But Mr. Newton was charged with an offence, an SUL offence against his wife. But he said, well, it was consensual. But at the time, what he did, it was an offence whether it was consensual or not. But obviously the court said that would make a huge difference to sentence, because if people, were happy with this, then yes, technically it is an offence, but it's not something the state should interfere with. Whereas if this is non-consensual, then there's a very serious offences. So they said, how do we decide this? And they said, we have a hearing to decide the facts. And this is now what we call a Newton hearing. So a Newton hearing can be triggered where there is a dispute as to the factual basis of the plea. Because like I say, you'll try to do agreed facts. And you'll sit with the prosecutor and say, well, look, shall we just say it's this, this and this? Now, the duty of the prosecutor is, they can only agree facts if they accept there's a legitimate evidential basis for doing that. The mere fact that they cannot gainsay something you are saying, because, only the defendant has personal knowledge of that. And they say, well, actually, what really happened is this. And the Crown say, well, we can't disprove that, but we don't necessarily accept it, then the court says they shouldn't agree that. They could just say we can't gainsay it. But it's still up to the judge to sort of exercise a little bit of discretion, because Newton hearings are done in open court, but with the judge, not with the jury. And you can have them affect like little mini trials. You know, you can call evidence. And indeed, if the defendant is putting forward a basis of plea that only they would know about, then generally speaking, unless they give evidence and say this is what happened and can be subject to cross-examination. I mean, a very common one is, yes, I was smuggling those items or distributing those items, but I was doing it under duress. I was being forced to do it. Now, that doesn't amount to a defence in law, I accept that, but it's got to go to mitigation that I was being forced to do this. But the court is allowed to say, well, you've got to tell us that, and you've got to subject yourself to cross-examination. We're not just going to take counsel's word for it, that's the basis of plea. But yeah, you know, so that's how you do the agreed statement of facts. And if you can't agree, then you have the Newton hearing. Judges don't have to have it. If your version of plea is completely implausible, you know, aliens made me do it, then the judge can say, I don't care. But also, like I say, a judge can say, well, if it's a relatively minor difference and it won't really affect sentencing, we don't need one. But if it's a situation where, yes, you know, depending on which version of facts come out, then it would very much change things. Like I say, you have the Newton hearing, and you can just do submissions and say, well, look at the witness statements, etc., etc. You can form your own view of that. But sometimes you will effectively have like a little mini trial on it. So yeah, so there you go. So that's how we decide, you know, what people are pleading guilty to, and also we get the indications. So again, you know, you could actually try and get an indication and sort of say, well, bear in mind, you know, here's the two versions of what he's up for. What sentence would you give in either case? Because if the judge says, you know, well, he's not going inside on either version, you might say, well, do we really need a Newton hearing? But if it's going to be, you know, affect the sentence substantially, then it's not an uncommon procedure. So there you go. So, like I say, the summary is we don't officially have plea bargaining in this country. However, you can get an indication from the judge if you were to plead, and you can agree the facts with the prosecution as to exactly what basis what you are pleading to. But if there's a dispute about the facts, then you can have these Newton hearings. There you go. So I mentioned the American situation early on. Generally speaking, even though they have formal plea bargaining over there, where the defence and the prosecution can say, well, we'll plead to these on this basis, and we'll, you know, the prosecution say, we will only ask for this sentence. The judge isn't bound by it. In a lot of jurisdictions in America, judges can say, I reject that. I don't think that sentence, you know, that you've agreed between yourselves reflects the situation. In those situations, the defendant can actually withdraw the plea, and it's on a without prejudice basis. So they can't say, well, you know, members of the jury, he actually pleaded to this when he thought he was only going to get like a non-custodial, but now he's fighting it. It starts from scratch. So you can withdraw the plea, but on a sort of, you know, neutral basis. But this is what happened with Roman Polanski. There'd been a plea bargaining, and they had agreed and said, if you plead to this, then we will say to the judge, we accept it can be a non-custodial sentence. But the judge came and said, well, no, this is like, you have just R-worded, you've drugged and R-worded a 13-year-old girl. Of course you're going to prison. So he said, okay, we need some time to think about this as to whether we're going to go forward with this or withdraw the plea. And then, of course, Polanski just skipped the country and has been on the lam ever since. So that's the American system. But anyway, as always, hope you found that vaguely useful, vaguely informative, vaguely accurate. And yeah, I don't know when this video is going to go live, but if it goes live before the sentencing, hopefully it will explain, because what is probably now happening is there's probably some attempt at doing an agreed basis of plea, you know, although the guy had up until then been very non-responsive and non-communicative, so it might be they just can't get any instructions. And the trouble with that is, if you can't get instructions, it's very difficult to do an agreed basis of plea or to mitigate, because it might just be you said, yeah, I accept that, yeah, I'm going to plead guilty. Why? Well, you know, I accept I did it, but I'm not going to go into any further details. I mean, obviously, when you do plead guilty, you distinguish the Newton hearing between mitigation. Mitigation's a separate thing. That comes after you have pleaded. You can then put all the stuff in and say, well, this is all the reason why, you know, I should get a lower sentence. Although, to be honest, in practice, sometimes that does get a little bit muddled up with the Newton hearing. Because, say, for instance, duress is very good mitigation. And if you've already discussed duress in the, you know, Newton hearing and said I was acting under duress and the judge has accepted that, then you don't really need to re-mitigate on that. You say, well, Your Honour has accepted that he or she was acting under duress, so I don't need to mention that again.